Good afternoon, everybody. Welcome to another webinar from the TUC. We're actually breaking records today. There are very nearly 2,000 of you joining us, which is fantastic. And we're just so pleased that so many of you keep coming back for more webinars. I'm joined today by Seery from Thompsons Solicitors, and I'm going to get her to introduce herself in a second. But we're going to talk about a little bit about our usual housekeeping before we get going. So I'm Anna, as many of you know. We do have live captions on today's webinar. Please click the green button that's underneath the videos of me and Joe, and they will open for you. Anyone who registered for today's webinar before 12 noon, we sent you today's presentation in advance because you'd registered by then. So some of you will have it and some of you won't, but don't worry if you haven't, because we'll make sure that we send it on to you after the live broadcast today, along with the recording, like we always do. Also, if you're joining us live, you will receive a TUC digital credential to recognise that you've done this important update with us. We know how important employment law is for all union reps, and we know that this is probably our most popular event of the year, which is why we want to recognise that you've joined us to learn all about the employment law changes that we've seen in the past 12 months. Do look out for that as well. It'll arrive by email. We've got a huge amount to get through today. So once we get going with Joe, we still want to hear what questions you've got, what might be going on in your workplace around employment law. We might not be able to answer them all because of the sheer number of you and because we've got a lot to get through. But please don't think we ignore the questions. We take all those questions, we note them down, and we use what you're asking us to plan further training and further events. So please do that. And as ever, great to see so many of you introducing yourselves in the chat and exchanging ideas and tips on what's going on in your workplace, because we always love to hear. Right, I'm going to ask Jo to introduce herself. And while she's doing that, I'll get the presentation up on the screen and then we'll be ready to go. So Jo, over to you. One second. There you go. Off you go.
Thanks very much for that introduction. Yes, I'm Jo Seery, and I'm a solicitor at Thompsons Solicitors. I'm also got this fancy title, professional support lawyer, which means that I help out colleagues. I also do presentations for unions on employment law. Some of you I may have seen. I'm not looking at all the chat, so I've probably seen some of you before. So it's nice to be back. And as Anna said, we've got quite a lot to get through today. So I think the PowerPoint's up and ready to go. So if you can turn to the next slide. I think apart from the fact that this government has been attacking trade unions and being completely focused on undermining members' rights to strike, there has until now been a dearth of employment law reform. The government abandoned, some of you may remember, the fact that it was going to introduce an employment bill, and instead decided that it would take the unusual step of backing private members' bills. And that's what we see today, is a rush of employment law. No coincidence whatsoever that we're now in the year of an election, possibly, unless he leaves it till January next year. And so we've just got so much legislation that's come in. And when I've done a previous presentation, I think I've mentioned that this legislation is coming in. So I'm going to try and give you a bit more detail and hopefully some tips that you can pick up with your employer, some negotiating points to raise with the employer in light of the new legislation that's come in. So there's legislation that came in force on the 1st of January, 1st of April, 6th of April. So you can see there's been a mad rush and it doesn't look like there's going to be any let up. So I'm going to look at that in some detail. Then I'm going to come on to look at some key cases which are really important for trade unions. And if I get chance, then we'll look ahead. But, you know, I am keen to hear from you. So long as you don't ask me too many tricky questions, then that'll be great. So if you can go to the next slide, please, Anna. So what we're looking at is legislation in force from the 1st of January. And what we see, not surprisingly, is the government's focus on working time regulations. Now, we all know that this has been the bane of this government and many employers, and it's caused, no end of issues in the workplace for you as trade union representatives. And, the significant cases that have subsequently led to some of these changes in the legislation have been as a result of union-backed cases. And what has happened is that the government has taken the step under the revocation legislation to codify the way in which EU law has interpreted some of the working time provisions. But unfortunately, it hasn't done that in a very coherent way. And that means that you might have more questions than I can give you answers. But you can see on this slide here that the first thing that the government did was to amend the record provisions. Now, European case law had said that employers have to have a system in place to measure the daily working time of all workers. And the government has weakened that provision by saying an employer need not record each worker's daily working hours as required by the case law if the employer is able to demonstrate compliance without doing so. But realistically, no action was ever taken against employers for not keeping adequate records. So query whether or not this is going to make much of a difference. What is key, though, is holiday pay. And so there is a new provision which provides that holiday pay for the 4 weeks statutory holiday for those who work normal working hours is prescribed. And what it does is it puts into the regulations the case law, particularly BA v Williams, which set out all those years ago now what should be included when you're calculating holiday pay. So it provides that it includes payments which are intrinsically linked to the performance of tasks which a worker is required to carry out under the terms of their contracts, payments for professional or personal status. So that might be things that you qualify for as a result of long service or because of your seniority or because of the professional qualifications that you hold, and other payments such as overtime payments. So we all know that overtime payments have actually been, the source of quite a lot of litigation supported by trade unions to ensure that workers get the holiday pay that they are entitled to. Now, these regulations are also supported by some guidance that's been produced by the government on holiday pay. And what that says is that holiday pay should be paid at the worker's normal rate of pay and include regular payments such as overtime, regular bonuses. But the 1.6 weeks leave is paid at basic rates. So we've still got that division. Some of you remember that the 4 weeks leave, which is based on the European case law, should be based on normal pay, so including all those payments that I talked about, and 1.6 weeks leave, which is paid at basic pay. Now, the main changes on holiday pay affect irregular and part-year workers. So there are two aspects to that. The first is how holidays accrue for irregular hours and part-year workers, and then how it's paid. So in terms of the accrual system, the legislation now provides that there is a specific system that applies to irregular hours workers. So what's an irregular hours worker? Well, that is defined in the regulation as somebody who works variable hours in each pay period. So it typically includes casual workers and 0 hours workers. Part-year workers is somebody who is required to work only part of the year and have periods in the year of at least 1 week where they don't work and they're not paid. So this would cover hourly paid term time workers. So in relation to those workers then, in a common trend that we're seeing now with this government, they have overturned or they have reversed the decision of the Supreme Court, which is obviously a hot topic in the news, and in relation to the judgment in Harper Trust and Brazil. So that case ruled that employees who work for part of the year or irregular hours workers are entitled to 5.6 weeks holiday pay, just like the rest of normal hours workers, and that the way in which holidays accrued at 12.0% was unlawful. So the government, true to form, has reversed that decision and now sets out new regulations which essentially say that holiday is calculated in hours for irregular hours and part-year workers only, so not for those who work normal hours, at the end of each pay period at the rate of 12.07% of the hours worked in the pay period. And the 12.07%, some of you may remember, is basically 52 weeks less the 5.6 weeks, and then written as a percentage. And I've given an example there of how it's applied. If somebody works 80 hours a week, you apply the percentage, 80 hours in a month, sorry, not in a week. But if the pay period is a month and they work 80 hours in that month, then you apply the percentage to that month to get the hours that they have accrued within that month. So for irregular and hourly paid workers, the accrual is over the pay period. In terms of how that is paid, then this is based on their average pay over the previous 52 weeks in order to get an hourly rate of pay. And that I won't go into the complications of that, but that's the general principle. And as well as that, employers can also now pay rolled up holiday pay. So provided they identify an element of pay which is in addition to your basic pay or your normal rate of pay, then if they can apply the 12.0% to your wages and apply that as an uplift to your workers' pay. So it should be in addition. It's not an opportunity for employers to now start deducting pay or trying to reduce pay. This is an uplift, and the regulations are clear about that. So that's in relation to irregular hours workers. In terms of another provision, the other point I wanted to make about this is that these provisions on how holiday is accrued and how it's paid apply from the 1st of April 2024. So it's all for, if some people like myself, our holiday year starts from the 1st of April and goes up to the 31st of March. But if your holiday leave year runs from January, so it started this January, then these provisions don't apply until the next holiday leave year, so from January 2025, because otherwise it would be unfair. This only applies where the holiday leave year begins on or after the 1st of April 2024. Now, I know that some parts of the legislation provide that holiday leave year starts from the day that you start employment, so some people can have lots of different start dates, but so long as the holiday leave year starts after the 1st of April, then this is the way that the employer can calculate your holiday entitlement and your holiday pay. But if it's before then you have to wait until the end of the leave year. So I hope that's clear for everybody. In terms of being able to carry forward unused holiday entitlement, the general principle has always been is that you can't carry forward. Now the regulations, to reflect the case law that's developed over a number of years, have been amended so that these now provide that workers who have normal working hours, they can carry forward 5.6 weeks of the whole of the leave year into the next leave year if the reason that they haven't been able to take the holiday is because of statutory family leave. And so that is maternity pay, paternity, shared parental leave, adoption leave, those types of leave. Then for those reasons only, and they haven't been able to take it, then they can carry it forward into the next leave year. If the reason they haven't been able to take all their leave within the holiday leave year is because of sickness absence, then they're allowed to carry it forward, any unused leave in that leave year, for a period of 18 months from the end of that leave year. So if you've been off sick and you're still off sick, say to the 31st of January, 31st of March, you can carry it over for another 18-month period. So you need to be able to watch that and keep an eye on dates for how long you can carry it over. And now workers on irregular hours can carry over all leave untaken on the same basis as above. So what I should have made clear is that there is a distinction between being able to carry over all your 5.6 weeks leave if you've not been able to take it because you've had 12 months maternity leave, for example. You can carry that over into the next leave year. But if you've been off sick, the period of leave you can carry over for a period of 18 months is just the 4 weeks leave year. So hopefully you can see that there's a distinction there between what you can and can't carry forward. For irregular hours workers, because of the way that holidays are calculated, there isn't that same distinction. They can carry their leave forward on the same basis as the above. So if they've taken statutory or family leave, they can carry it over into the next leave year. If they've been off sick, then they can carry it over for 18 months from the end of the leave year. So from the end of, from the 1st of April, whatever it might be. Workers can also carry over leave which was untaken or taken, but the employer didn't pay them for it because of a failure by the employer to either recognise the workers is entitled to holiday pay, or that they didn't pay a worker for leave that they had taken. So the law there says in those circumstances, the leave can be carried forward for each year that the employer fails to either recognise a worker's right to holiday entitlement, paid holiday entitlement, or they fail to recognise that they pay a worker for holidays that they have taken. But leave cannot be carried forward beyond the end of the first full leave year if there wasn't a failure by the employer. So if the employer has failed to pay it in the past and now starts paying it, then you'll need to take advice about time limits for bringing a claim if the employer suddenly thinks, well, now we'll start paying it from this particular year. So there are a couple of things that I think are important about the amendments to holiday pay, and a couple of things that I wanted to draw your attention to watch out for. The first thing is check the contract to make sure when the holiday leave year begins, so that irregular hours and part-year workers still benefit from the better calculation of holidays that applies until the next holiday leave year begins. And when calculating the amount of holiday pay for irregular and part-year workers, employers can round up or round down to the nearest hour. So anything less than half an hour is rounded down, and anything more than half an hour is rounded up. So I've given an example there. And what I've done is if a worker works 85 hours in April and then 70 hours in May, you add those two together and apply the 12.7%, and you get 19 hours. Just going to have to take my word for it. There's no time to do the maths. But if you worked on the basis, if you calculated 12.7% on 85 hours in April and then 12.7% on 70 hours, the actual hours you would get would be 18 hours holiday. So you need to, and unions may need to pick this up with the employer to work out how holiday pay is going to be calculated. Is it per month or is it over the year? And obviously you can work out which works for your members' best advantage when you're, so you can negotiate with the employers how it should be done. Employers may pay rolled up holiday pay, but that only applies to irregular and part-year workers. And the key thing here is to check the contract and see how holiday pay is calculated, because if the contract specifies how holiday pay is calculated, and it may well do that because of the provisions under the Employment Rights Act, which provide that an employer is required to provide a statement of particulars and to set out how holiday, which includes to set out how holiday pay is calculated, then it may well provide for that. And any attempt by the employer to introduce rolled up holiday pay may amount to a breach of contract. So you'll need to check what your contract says and see if it sets out how holiday pay is calculated. In terms of carryover leave, then the guidance is quite clear about that. Employers shouldn't be introducing any clauses which say that you use it or lose it, because there are these carryover provisions. And the other thing is that the legislation says that employers, well, effectively says this: if employers fail to encourage workers to take their leave, or they fail to give them a reasonable opportunity to take it, or they fail to advise workers that they may lose it, then that might give rise to a legal claim. Now, there's government guidance, and there is some commentary which says that it doesn't necessarily reflect the regulations, and that's true. But it does give some examples of how holiday pay and entitlement is calculated. So take a look at that, and the link is there within the slide. In terms of the Equality Act, then there are a number of amendments. I think I've talked about these before. The definition of disability is amended so that it provides a person's ability to carry out normal day-to-day activities, includes the person's ability to participate fully and effectively in working life on an equal basis, provided with other workers. So effectively, it should make it a lot easier for those who fall within the definition of disability, or to fall within the definition of disability, because workers can look at particular tasks that they do at work. So, infrequent tasks or one-off work activities such as job applications or examinations, if that puts them at a disadvantage with other workers so that they're not on an equal basis, then that will give an indication as to whether or not they fall within the definition of a disability. It also ensures that activities that aren't common to the majority of jobs, so like driving or carrying boxes, are relevant activities when you're determining whether or not somebody falls within the definition. So it's a much wider definition, because it's not just looking at, ability to be able to go shopping, climb stairs, open doors, ability to concentrate, but looking at the nature of the job and whether or not a disabled worker can actually effectively have a good working life which is equal to those of their colleagues. The other key amendment here is in relation to the provision of indirect discrimination. So there's a new section 19A, which says that indirect discrimination can apply to a worker where a worker doesn't have the relevant protected characteristic, but they suffer substantially the same disadvantage as those that do have the protected characteristic. So the classic example of this is where a man who has got primary responsibility for childcare applies for flexible working and is refused it. Under the previous provisions, he wouldn't have been able to bring a claim for indirect discrimination because he doesn't share the protected characteristic of a woman. And it's broadly accepted that women have the main responsibility for childcare and who may be put at a disadvantage by any refusal to grant a flexible working request. This provision now provides that where a man is refused flexible working because he's a primary carer for children and he suffers substantively the same disadvantage as those women, effectively, then he may be able to bring a claim for indirect discrimination. Indirect discrimination, you should remember, is still open to a defence by the employer because they can justify the discrimination if it's a proportionate means of achieving a legitimate aim. So it doesn't mean that it's a cast iron shoe-in on a claim, but it does open the doors to those types of claims. The other amendments include expressly providing that it's direct discrimination to treat an employee less favourably because they're breastfeeding in the workplace. Previously, that didn't apply. It extends the protection for workers who are subject to unfavourable treatment after they return from maternity leave, where that treatment is related to pregnancy or a pregnancy-related illness which occurred before they returned to work. So I think the things to watch out for here are protection for women who suffer from postnatal depression. Previous case law has been very, very difficult because the protection didn't apply once a woman had returned. Pregnancy, unfavourable treatment because of pregnancy didn't apply when women return from work. Now, if the reason for the unfavourable treatment emanates from their pregnancy or from a pregnancy-related illness like postnatal depression, then they may now be protected under these provisions. The last one provides that discriminatory statements that are made in a recruitment exercise are unlawful, even if there is no active recruitment or identifiable victim. But those are claims that are brought by the Equality and Human Rights Commission. So I'll say not much more about that. We've also had changes to the national minimum wage. These came in from the 1st of April. So unlike the other slides that I was looking at that came in on the 6th of April, the national minimum wage changed on the 1st of April. And the key thing to note here is that the higher rate now applies to those over the age of 21. So before, the higher rate only applied to those over the age of age 23 and over, and there was a separate rate for those who were age 21 and 22, a lower rate. Those age 21 now qualify for the higher rate. Next slide, please. Sorry, I'm not telling you what it is. So the other legislation that came into force on the 6th of April is the maternity, I think these are referred to as the MAPSA regulations, maternity, adoption leave and shared parental leave regulations. And what these do is extend the requirement on employers to offer suitable alternative employment. So previously, Regulation 10 of the MAPLE regulations provided that if there was a woman was on maternity leave and there was a redundancy situation while she was on maternity leave and there was suitable alternative employment available, then the employer was obliged to offer the woman on maternity leave the suitable alternative employment. So effectively, it put women on maternity leave at the top of the pecking order where there was suitable alternative employment. Those provisions are now extended to pregnant workers who inform employers of their redundancy. So if there is a redundancy situation shortly after a woman notifies the employer that they're pregnant, then the employer, if there is suitable alternative employment available, then the employer should offer it to the pregnant worker in terms of the pecking order. Employees who've returned from statutory maternity leave or adoption leave, which ends on or after the 6th of April, and employees who've returned from a period of at least 6 weeks shared parental leave, which starts on or after the 6th of April, they are now in a protected period so that the period is extended to 18 months from either the expected week of birth, the date of birth, or in an adoption situation, the date of placement, or entry into GB if it's a foreign adoption or a surrogacy arrangement. So in those circumstances, if there is a redundancy situation in that 18-month period, so this is 18 months from the expected week of birth, date of placement, then those people are, and there is suitable alternative employment available, then the employer should offer them the suitable alternative employment. So we might see situations where you've got a number of people who are affected by this, and the questions will be raised about who gets to the top of the pecking order list in those situations. But so far, we all thought that would happen before, but I've never really seen it come up. So the key thing is that there must be suitable alternative employment available. So if there's a suitable job, if the job isn't suitable, then the provisions won't necessarily apply. There are also amendments to the paternity leave amendment regulations. And what these do is allow fathers and partners to take paternity leave in 2 separate 1-week blocks. Previously, they could either take a 1-week block or a 2-week block, but they couldn't take separate 1-week blocks. Now they will be able to from the 6th of April. Fathers and partners can also take the leave at any point in the first year after birth or adoption of their child. Previously, it was limited to the period of 8 weeks after the adoption or the birth. And the notice periods are also shorter. Effectively, they're now 28 days before either the date, a specified date. So if somebody has said, well, I want to go on paternity leave on this date, then they'll have to give 28 days notice of the date they want to take that paternity leave. If they want to change their mind, then they can give notice, but again, they have to give 28 days notice of the variation. So that's 28 days notice of the new date, if that is after the first date. In any event, it's got to be 28 days before the paternity leave starts. An SSP has changed to reflect that, so that SSP, I think I've worded that quite badly on the slide actually, but effectively SSP is payable for each week now of statutory paternity leave taken within the 52-week period. So because parental paternity leave can be taken at any point in the first year, so you might want to take 1 week at the beginning, 1 week later on, then you still get paid for it under the statutory paternity pay provisions. But the paternity pay, aside from the slide that I've given, it hasn't gone up that much. The other key amendment is in flexible working regulations. So these amendment regulations apply to requests that were made on or after the 6th of April. So these all apply now. So the right to make a flexible working request applies from day one in employment. So previously had to have 26 weeks service by the time of making the request. Now it's a day one right. It's still only a right to request. It's not a right to be given flexible working, but it does mean that people can request it from day one. The request should still be in writing. It should be dated and state that the request is made under the statutory procedure, and what type of flexible working it's going to be, change to the hours, the times or the place of work, the date when it's going to start. But it doesn't have to set out the effects of the flexible working request on the employer. That provision has now been removed. You don't have to explain how it affects the employer or how any provisions can be overcome. And I've given a link in this slide to the government has produced a right to request form. I must admit, when I had a quick look at it, I don't think it met all the other provisions that I've just talked about, but that's the form that they've got. So take a look at that. It might be useful, especially when you're dealing with small employers, because it makes clear the other key provision is that the employer has got to make a decision within 2 months of the flexible working request. So you can make 2 requests in a 12-month period. You can make them from day one in employment, but the employer must notify the employee of their decision within 2 months of the flexible working request. Previously, the employer had 3 months, and I think some employers were struggling with that. But now it's 2 months, and that includes any appeal. So it'd be interesting to see how that develops. There are provisions which allow, that's not a change, but the current provisions allow for the parties to agree an extension. But what an employer can't do is say that the appeal is after the 12-month period. And because the worker turns up to the appeal, states that, that amounts to an agreement to an extension. The case law of Walsh has said that that's not the case. The other key aspect is that the employer must not reject the request unless it's consulted with the employee. So the ACAS Code of Practice makes it really clear that while there is no obligation on the employer to have a meeting, it recommends that because of this obligation to consult with employees, then the employer should generally hold a meeting with the member who's made the flexible working request so that they can discuss it and consider it. So it doesn't, the legislation doesn't set out the form that consultation should take. But if an employer doesn't consult before they reject a request, then an employee can make a complaint to an employment tribunal if they don't do that. So whizzing on to the next one now, I'm trying to go as fast as possible. There is the carers leave regulations. These apply from day one, and they apply to those who have got a dependent for the purposes of carers leave. And a dependent is a spouse, a civil partner, child or parent of the employee, and they live in the same household as the employee, and they're not a lodger or a tenant. It applies to dependents with long-term care needs. So what does that mean? A long-term care need is somebody who has an illness or injury, that can be physical or mental, that requires or is likely to require care for more than 3 months, or they have a disability, or they require care for a reason connected with old age. It's 1 week's unpaid leave in any rolling 12-month period, and leave can be taken in one continuous block or separate days. The minimum amount of unpaid carers leave that can be taken is half a day, and you do have to give the employer notice, and the minimum amount of notice you have to give, even for half a day, is 3 days notice. So it's not like the other leave, which is the emergency leave. It's something separate from that. It might be that you're planning to look after somebody because they've their caring arrangements might have broken down, but you give an advance notice. It's not the emergency leave, it's something separate from that. But like the emergency leave, it's not paid for. Generally, you have to give twice as many days as the leave requested. As I've said, if you're doing half a day or 1.5 days, then the minimum period is going to be 3 days. If you're taking 2 days, then it's going to be 4 days notice, and so on and so on. The notice doesn't have to be in writing, and you don't have to provide the employer with any evidence that that's the reason that you're taking leave. I think these provisions might have been different if there was a requirement to pay for it, but there's not. An employer can also decline a request, but they can only postpone it if they can't decline a request, they can only postpone it. And they can only postpone it if the employer reasonably considers that the operation of the business would be unduly disrupted if it allowed the leave during the requested period, or the employer allows the employee to take a period of carers leave for the same duration within a month of the original request. So they can say it'll disrupt the business, or they can postpone it and say, well, you can take it within a month. Or if the employee gives the employer written notice within 7 days of initial request, setting out the reason for the postponement, then they must agree the dates that the leave can be taken. And workers are protected from the usual right not to be subject to a detriment or dismissal because they've taken or requested or sought to take carers leave. I set out there the statutory compensation limits, which increased, and you can see that when I've talked about maternity and paternity pay, that's increased now to £184.03. Sadly, SSP falls short of what we as trade unionists think should be payable. But that has increased slightly there. And the basic, I suppose, the other key thing to look at is the basic award in a claim for unfair dismissal, because that's the rate that's used to calculate statutory redundancy pay for those that earn more than that. The injury to feelings awards has also increased, so anybody negotiating in a discrimination matter needs to be looking at these bands which have increased from last year, so that the upper band now is 58,700. But generally, I find that most cases fall within either the upper end of the lower band or within the middle bands. So that gives you quite a bit to go on when you're negotiating with employers. Whizzing along now. So that's the legislation for that year, for the that we looked at 1st of January, 1st of April, 6th of April. And I just wanted to look at some of the key cases now. So if you can turn to the next slide. This judgment is of huge importance. It just came out the other week. Some of you may already be aware of it. And the whole issue about Mercer was whether or not somebody who take industrial action could be protected from being subject to a detriment. So Section 146 provides that workers are protected from being subject to a detriment by their employer where the sole or main purpose is to prevent or deter them from taking part in the activities of a trade union at an appropriate time, or penalising them for doing so. So what this case considered was whether or not activities at an appropriate time included industrial action. And what the Supreme Court has said is that there is a lack of statutory protection for workers who are subject to a detriment for taking part in the activities of the trade union. And what they did was make a declaration of incompatibility, because it doesn't protect workers who take industrial action from being subject to a detriment. Therefore, it's incompatible with the right to strike under Article 11, which is the right to freedom of association. And what the court said is that by allowing an employer to impose a sanction short of dismissal for participating in lawful strike action effectively undermined the right to strike, and that's why it's a breach of the European Convention on Human Rights. But the court could not read the statutory wording in such a way as to say that the legislation should be amended, because that would be going a step too far as the court's ability. The court is not allowed to make legislation, but what it has done is said that it's incompatible with the European Convention of Human Rights, so it's therefore left to Parliament to decide whether to amend the legislation. So, good employers will say, well, we shouldn't subject you to a detriment, but that might be the subject of negotiations with the union, in the same way that the union has successfully been able to work with employers so they don't issue notices where there's minimum service levels. Likewise, here, you may get employers to agree that it's not a good idea for them to subject workers who've taken part in industrial action to a detriment, because we might be waiting a long time for Parliament to make the amendments to the legislation. So again, it's left to trade unions to negotiate with employers and apply collective pressure on them. Another case which I think is really useful for unions is the duty to consult. So in this case of DeBank Haycox, the Employment Appeal Tribunal considered whether a dismissal for redundancy is fair when there's been no collective consultation with the workforce in a workplace where there was no recognised union. So this was a typical example whereby the employee was employed as a recruitment consultant. It was a UK subsidiary of an American company. There was a downturn in the business. The employer, ADP RPO UK Limited, decided it was going to make redundancies. And what it did was it took the selection criteria from the main company, the United States-based company, said, oh, we'll apply that criteria, which was effectively subjective criteria, 7 different categories. And, lo and behold, Mr. DeBank Haycox scored the lowest. And so he was invited to several meetings, but he was ultimately made redundant. And he appealed against the dismissal decision, firstly because he wasn't given his scores by the time the employer notified him that he was dismissed for redundancy. When he appealed, he had been given the scores. And when he took his claim to the Employment Tribunal dismissed his claim and said, well, he hadn't provided any evidence to show that he would have got higher scores, and so his job was safe. He appealed that on the basis that the Employment Tribunal had overlooked the fact that the employer is obliged to have consultation, and that consultation, as a matter of good industrial practice, should be at a formative stage. So because the employer had just gone straight to applying the criteria without having a consultation before about that criteria and about alternatives to making redundancies, the EAT said that the employer, that he was unfairly dismissed. And so the EAT said that early workforce consultation on the methods of selection and meaningful consultation on avoiding redundancies is necessary to ensure fairness. It's unreasonable for a UK company to simply adopt the US selection criteria. It didn't reflect good industrial relations practice in the UK, and there was no good reason for the employer not to have consulted with the workforce. So I think that gives unions a bit of an in where the union's not recognised, to get in and have those collective consultations with the employer. So I think that's a good decision for union reps. In terms of automatic unfair dismissal, this concerns a case of somebody who was dismissed because they sought to take unpaid parental leave. And again, this is an interesting case because it sets out that where an individual makes informal inquiries as to whether or not they could take parental leave, there's no requirement for them to have actually put in an actual request. So what happened in this case was that Mr. Wright was making some inquiries about whether or not he could take unpaid parental leave. That was just stonewalled by the employer, and he was subsequently dismissed, allegedly for redundancy. He was able to show that that the reason that he'd been made redundant was because he'd sought to take parental leave by making these informal inquiries, and his claim was upheld. So that shows you that if you're making informal inquiries, you don't necessarily have to have a written request, which is what the employer was arguing in that case. This is an agency workers case, and I maybe skip over some of these because I'm realising that I'm only giving 10 minutes for questions, and there might be quite a lot of questions, but it's something to look at. Basically, it says that agency workers who are between assignments, so in this case, the individual was suspended as a consequence of an incident, and she tried to argue that she should be given full suspension pay until she returned sometime about 5 or 6 months later. And the court said, no, the way that the legislation is drafted is that a comparison has to be made with somebody who is actually working at that time. So you can't make a comparison between those who are directly employed and agency workers where they're between assignments. This is another good case for unions because this is a case where the Employment Appeal Tribunal held that a trial period can be a reasonable adjustment. So that's really useful where somebody is no longer able to do their job. And Mr. Miller here had been diagnosed with multiple sclerosis. He could no longer do his job as a field pest controller because he couldn't climb posts and various different things as a consequence. He applied for another job, but he wasn't successful in it. And he argued that it would have been a reasonable adjustment for him to have had a trial period. The key thing about this, though, is that he needs to be able to show that it was a suitable alternative job. And the fact that he was shortlisted for it and interviewed indicated that it wasn't a job that he wasn't suitable for. So it would have been reasonable, the EAT said, for the employer to have given him a trial period rather than just saying, well, you're not selected and therefore you're not suitable. So I think what that means is that unions can push for individuals to have a trial period in a job that they think they're suitable for, rather than being put under the pressure of having to apply for a job and then being rejected. So I think I might cases to watch out for. I think I might pause there, but leave you to have a look at some of these. I've talked about some of them before. Some of you will know about them. So you can. I've given a summary on the case slide. So is that okay with you, Anna? If we just pause there.
Absolutely. Jo, you have given us such a phenomenal amount of incredibly useful information and detail. I'm blown away, and I'm sure the audience is as well. I absolutely agree. We should we've only got about 10 minutes left, and we will send the slides to everybody who has signed up for the webinar. It's over 2,000 of you, along with a recording of today. So please don't think we're sort of missing out information. We absolutely aren't. We've had over 50 questions, so can't wait to see how we do this. What I'm going to do is pick the ones that have we've had a lot about the same subject, really, and just put some of those to you in quite a general way. So we've had a lot of questions about reasonable adjustments and the Equality Act, disability as a protected characteristic. So, for example, can you ask for adjustments during an application process, or is it only once employment starts? Are there any cases on this? Or, what can reps look out for, be aware of?
Yeah, there are a number of cases on this, and I'm just trying to remember the one now where it was to do with online applications and whether or not that I can't remember the name of the case now, but was to do with online applications, and because of the person's disability, they didn't engage with the employer about the online application, but their disability meant that they found it difficult to set up a password and all the hoops that you have to get over with trying to complete online applications. And he was held to have been subject to a disadvantage because the employer hadn't discussed with him an alternative way of making his application. So in short, yes, it can apply to the application process.
That's great. Thank you, Jo. Coming out under the definition of disability, do periods in life, for example, menopause, also fall under that, or is that to be considered under a separate part of the law?
Right, so menopause, so there are some cases which have held that menopause can amount to a disability, but it has to fall within that definition. So you have to show that there is a physical or mental impairment which has a substantial and adverse effect on your ability to carry out normal day-to-day activities. So menopause itself isn't defined within the Equality Act as a disability. Women would have to bring themselves within that definition, and because they're not going to probably struggle to do that, because if it affects ability to concentrate, for example, that might be and it affects normal day-to-day activities. And also now we've got that broader definition, so if it puts them in an unequal position, there are aspects of their job that they can't do because of their menopausal symptoms, and those are things that their colleagues can do quite easily, then they may well be able to bring themselves within that definition. But you go back to that definition first, work your way through it, and set out how it has an impact on your ability to carry out normal day-to-day activities or puts you in an unequal position. But equally, just to quickly say, it may also amount to sex discrimination or indirect sex discrimination, because cases have been brought on that basis as well.
Thanks, Jo. So a couple of different areas for reps to consider there. That's fantastic. Okay, we've had a lot of questions about the holiday pay thing and holiday leave. I don't think we can even attempt to answer even a fraction of them. So what I'm going to do, and this is for the audience, me and my team will make a note of all of them, take them in hand, and work with our colleagues at the TUC to produce some fact sheets, sort of resource guides, and we'll publish that, and we'll make sure you're kept up to date when you know we've published these, because there's so many really good questions here that I think many people would benefit from hearing information about. The question we've had that's perhaps the most general in this area isn't about a specific of the law. It's more about what an employee or a union rep should do. So if an employer tries to change how holiday pay is calculated in a breach of a contract, what do you suggest a rep or an employee does in that situation?
Well, the first thing would be to lodge a grievance, and if it's affecting a number of people, then the union's in a good position to lodge a collective grievance about those changes. Point out that the grievance should be that the employer is acting in breach of contract by changing the way in which the pay is calculated, but you need to be clear, whether or not it's actually defined. So start off by checking the contract and whether or not that sets out how holiday pay is calculated. Then you may lodge a grievance on the basis that the employer's breached the contract if the changes aren't provided for in the contract, or you may then bring a claim that if the employer imposes that change, then we're back to what workers can do where an employer imposes that change. So you must work under protest at that point, and that can be done collectively through the union. So if a large number of people are affected by it, then a collective grievance is probably the best starting point. And then at the same time seek advice.
Yeah, absolutely. I think that's a really great point. The usual procedures that you use as workplace reps still apply here. Just knowing when to start them, to begin that process, they absolutely still apply, as well as getting advice from your union, from your full-time officer, if you're unsure. Okay, we've also had a lot of questions about flexible work. I thought we would, and about the timings really around requests. So if a decision by the employer is given outside of the 2 months, is there a recourse for that? And what happens if they don't? Well, basically the same thing. What happens if the employer doesn't give that information within 2 months? Is there a way to appeal that? If so, would an appeal work?
Well, then if the employer doesn't give a decision at all, the decision period comes to an end after the 2-month period. And then there's a technical breach of the flexible working regulations. So it's not massive amount of compensation, but there is a technical breach of the legislation at that point. So you cannot, you would, again, same thing, lodge a grievance because you're outside of the employer hasn't said that there is an appeal, and you don't want to run the risk of lodging an appeal and the employer saying, haha, you've agreed to an extension, even though the case law says you can't do that. So what you want to do is to lodge a grievance, keep an eye on the time limits. So work out when the 2 months from the date of the flexible working request was. That'll be your trigger for a time limits for a legal claim, and get advice from the union.
Thanks, Jo. And I think the final sort of theme of questions I'm going to put to you now is around stillbirth, miscarriage, because quite a few people have asked about that. Is there any case law about this, about time off, about flexibility, etc.?
I'm not sure of that. I'd have to just double check that position, because it's always a more complex area. So I'm sorry, I'm happy to look into, if you want to share that with me, Anna, I'm happy to look into it and give a bit. That's not a very satisfactory answer, is it? So
no worries.
It's just something that has not.
No worries at all.
Off the top of my head.
I'm surprised you can still speak to me after an hour of incredible information. I hope you do get a chance to look at the chat panel as well, Jo, because we're getting such fantastic feedback. People are saying they have learned so much. There have been a huge amount of changes for us to take in. And we really, we're going to wrap up now. Thank you so much for joining us. This is like the highlight of the webinar year in many ways, I think. our wonderful audience, thank you for joining us today. It's been a ball. I've really enjoyed it as well. Do look out for a recording that we'll send you. It might be first thing tomorrow morning, along with the presentation. And do as well look out for your digital credential that will prove that you came today and what you learned. Do come back for more from us soon with webinars. But for now, bye-bye.
Bye.